From now on. Thank you, Mr Chairman.
I'll call Lynn Pillay.
Thank you, Mr Chairman. Mr Chairman, I'm really happy to stand and I congratulate Rick Barker for a very good speech in terms of the of Part 3, and I think Part 3 is a very, very, very important part of the bill, and I know Carol Beaumont agrees with me and will probably take a call on this as well. In terms of the credit reporting, and that's proposing that the release of overdue, the penalty balance of overdue of eligible people via credit reporters, and this means that this would be able to be done using an automated information matching system. And we all know with knowledge comes power, and the ability to get the scheme for overdue penalties would be very, very helpful, Mr Chair. This scheme will not include overdue penalties subject to court orders relating to name or identity suppression of orders from either the youth or from the family court, and they will also not include people whose penalties are not overdue, including those subject to a payment plan. So good behaviour is not punished. If there is a process in place to pay back those penalties, then those people will not be part of the credit reporting scheme. The Ministry of Justice are authorised to use the information to collect those fines. This will lead to efficiency, and the amount, which I forget, the millions and hundreds of millions and out, will go a long way towards getting back so much of those the money involved with the unpaid fines. The bill does require the Minister of Courts to consult with the Privacy Commissioner before recommending any regulations implementing the exchange of information between the Ministry of Justice and the credit reporting industry. I think that, Mr Chair, is a very sensible move, whilst getting to the bottom of the debt, of getting that information, making that information available. It is also very important to comply with with people's right to their rights and entitlements to privacy. In terms of I have said in an earlier speech, but this part also recognises that the bill authorises prison or home detention sentences to be substituted for unaffordable and unenforceable repayments. Now that would be very regrettable. I wouldn't see, and I don't think anyone in this House would see that as a positive movement. But in situations where that debt cannot be repaid, then it does come to accountability, as my colleague Stuart Nash said. People in these instances are quite clearly breaking the law, and it is very important in our democracy that the law is upheld. So whilst the ability is there for that to happen, Mr Chair, I along with, I'm sure, everyone would hope that is not a frequent occurrence. There is also an amalgamation of all the existing provisions relating to seizures, and that's been reordered to better align with the more up-to-date seizure process. Now, in terms of there can be arrangements made, and I think this is a very progressive move, arrangements for longer time to pay fine or payments by instalments, because there is no point in insisting that a defendant pay a debt if there is utterly and completely no ability for that person to pay. So that this would give the court the ability to direct, rather than making the order itself, a registrar to determine whether it is appropriate to enter into an arrangement with the defendant, allowing a greater time to pay that fine or debt by instalment, or both. It could be a mixture of both, so that there could be an upfront payment and then a payment as affordable of instalments. That is, Mr Chair, that is a very sensible move, and in the long term or in the medium term, or will go towards a long way towards instead of a person, and we've already identified someone 69% between 20 and 39 years of age. That means that person has some hope of making that repayment, and that is actually a win-win situation. A win-win because the debt can be cleared, and for that person it's not a black mark against their character, which is available through a credit rate reporting agencies, but also means that those monies are able to be retrieved, be it that if it takes a longer time, so what? At least that money is being retrieved. Also, the registrar will have power if the fine is unpaid or if time payments arrangement or are cancelled. There is a provision in the Act setting out actions that a registrar may take if a fine or instalment is not paid, or if an arrangement extending the time to pay the fine or an attachment order is cancelled. I would actually ask the Minister, it would be very interesting to hear, because it's something not being on the Law and Order Committee and certainly not being the Minister who's overseeing the bill in the House, I'd really like to know how that would work in terms of if there is the ability for people in hardship to voluntarily go into that arrangement or to request that arrangement of the registrar. I'm uncertain of that, and I'm sure that Chris Finlayson, with his sharp legal expertise and ability to explain things, will be able to enlighten the House on that. He's certainly not backwards in coming forward and showing off his intellectual abilities in terms of the law. And I must say, I have at times heard some quite smart things come from him. He's a little bit remiss and a little bit backward in terms of the Sentencing Council. I know that that was always, as chair of the Justice and Electoral Select Committee, something that saddened me, but I can see that he's getting ready to spring to his feet and answer those questions that I've asked, and I think the House will be very appreciative of that. There are a number of other parts to this, Mr Chair, but I think probably I don't want to. I really would rather focus on the most important aspects, and as I said, the credit reporting, the ability, the prioritising of seizing of property, substituted sentences, a streamline which I didn't touch on. But the infringement system, the Proceedings Act has been amended to improve the operation of the system and the court collection and enforcement processes by looking at the inconsistencies there and just making the whole operation more effective, more efficient, and thereby a benefit again in terms of receiving and collecting those monies that are owed. So, Mr Chair, I think probably, I haven't had an indication from you, but I think I'm probably coming to the end of this call. Perhaps a little wink or a nod might help, but or a little smile, that's nice. It's always nice to see. But along with my colleagues, I'm very pleased that Labor is supporting this bill, even though we know that this bill has not gone as far as the recommendations and all the work that was done under the Labor government prior to this bill coming into place. And as we've said before, not wanting to be too churlish, but it is a pity that it has taken this long to come to the House, especially when I can see all the hard-working officials sitting in the chamber here, and I know they'll be very relieved, because it's been something that's been languishing on the paper for quite some time. Thank you very much, Mr Chair.
Chris Tremaine. I move that the question be now
I'll
put.
hear Carol Beaumont.